Wednesday, April 10th, meeting of the Lee County Zoning Board of Appeals to order. Would you call the roll, please?
Bruce Forster,
Here.
Craig Burrow,
Here.
Mike Pratt, Rex Meyer,
Present.
Luke Phelan is not present.
Do we have? Do we have minutes from the previous meeting? No. Okay. So we start on the old business. Petition number 24-P-1621, Pulse Solar 2 LLC. And I'd like to turn it over to our facilitator.
Thank you, Mr. Chairman. As the members of the zoning board are aware, well, let me back up. I would note for the purpose of the record, the elevator in the building is still out of service. There is a remote area on the first floor made available to those unable to come to the third floor. That is live, it's online. They are able to see and hear those of us in the courtroom, I believe. When we last left this hearing, we had concluded the public hearing portion had been formally closed. The evidence had been concluded from both the petitioner and any interested party that was present. When we concluded, one interested party, Dr. Sarah Willey, was permitted and advised she could submit documents following the hearing. So I guess first let's confirm what was received following the hearing. I'll ask our zoning administrator those questions.
I'm sorry, you want me to read describe the documents?
I don't think you need to describe. Did you receive the documents from Dr. Sarah Willey as she was allowed to submit?
Yes,
A packet of documents.
yes.
So those are available in the zoning office to any member of the zoning board. Were any other items received?
Yes, I also received a packet of documents and emails were sent out from Wendy Willett.
All right, so at the conclusion of the public hearing, leave or request to permission to submit additional records into the public hearing was not requested. So I guess what I would note for the record is that those documents are available in the zoning office. They're certainly available to any member of the zoning board of appeals. They were not evidence presented at the public hearing. If any member of the zoning board wishes to review those, they certainly may and give it any weight to which they feel it is entitled to be given. Anything else from the zoning officer?
Nothing.
Thank you. So tonight, we did conclude the public hearing. Tonight is to discuss, the members of the Zoning Board of Appeals to discuss the findings of fact as the county code provides that you are to do. The way we're going to proceed, for those of you present in the courtroom, what will happen is the members of the zoning board are going to go through criteria, things that are in the code that they're required to say, we agree, we disagree, and make findings so that the record is clear what their determinations or conclusions are. This will take a little while, and they are in pieces. Some are in longer chunks than other, simply because they fit together as one group. So we will begin, we'll read portions. Then the members of the zoning board, you'll have an opportunity to discuss that section. And depending on your views, either modify it or adopt it or reject it. And we'll do that in pieces as we go through. I will remind those present that this is an opportunity for the members of the zoning board to make these conclusions. And so please keep any comments you may have to yourself. We are still following the normal rules of decorum for a meeting of the zoning board. Any questions, members of the zoning board?
Are you reading them all?
Or
do you want us to? Oh.
Well, it depends on how my voice does after a while, probably, but I'll start. So this is a matter 2023 P-1621 to the Lee County Board, Lee County, Illinois, from the Lee County Zoning Board of Appeals regarding petition for special use permit, petition number 23 P-1621 for the development, construction, and operation of a commercial solar energy facility in Lee County, Illinois, filed by Pulse Solar 2 LLC. Report and findings of fact and recommendation adopted from the proceedings beginning April 3rd, 2024 and continuing through April 10th, 2024 today. Section 1 is entitled Petitioner Petition, Project, Notice, Facilitator, Process, Witnesses, Exhibits, Closing Statements, and Public Comments. The Lee County Zoning Board of Appeals, hereinafter ZBA, as authorized by Lee County Ordinance 2023-07008, herein finds as follows. Subsection A, the Lee County Zoning Board of Appeals, hereinafter ZBA, finds that on February 2nd, 2024, Pulse Solar 2 LLC, hereinafter referred to as Pulse Solar, the petitioner, the applicant, or the developer, an Illinois limited liability company, which is a wholly owned subsidiary of Ironwood Renewable, a Louisiana company, filed a petition for special use permit, which is numbered 24P1621, for the construction, operation, and maintenance of a 5-megawatt commercial solar energy facility, parentheses CSEF, including as designed a battery energy storage system, parentheses known as a BESS, supporting facility situated in Palmyra Township in Lee County, Illinois. Hereinafter, the petition, Pulse Solar, the project, the solar farm, or the development within the Lee County Zoning and Planning Office. And then you as members of the zoning board have, if you agree with that, then it'll be a motion to approve that section. If you disagree, it'll be a motion to reject that section. If you have changes, we can amend it and then have a motion by one of you to approve that section.
I would move to adopt that section.
I'll second it.
We have a motion and a second. Is there any discussion? Hearing none. All in favor, say aye.
Aye.
Aye. All opposed? Motion carries.
Move on to section 1B. The petition for special use permit. The petition was accompanied by supporting material in the form of 12 8.5-inch by 11-inch 3-ring binders. Hereinafter, the supplement, supporting material or supplemental material. A digital version of the supporting material was also provided.
Make a motion, we accept the statement.
Second.
We have a motion and a second. Any discussion on this? Hearing none. All in favor, say aye.
Aye.
All opposed? Motion carries.
Section 1C is entitled Notice. C1, proper notice of the filing of the petition and of the impending public hearing before the ZBA was published, as noted by certification, including in Zoning Officer Group Exhibit 5 in the Dixon Telegraph on February 7th, 2024. Subsection 2, United States Postal Service certified mailings of the same notice were sent by the petitioner to real estate property owners whose properties were identified by the petitioner as adjacent to the proposed project's boundaries, with such mailings be included as part of Zoning Officer Exhibit 5, postmarked February 20th, 2024. Subsection 3, Lee County Zoning and Planning Administrator, Ms. Alice Hinkle, supplemented the above notices as follows. Subsection 3A, by way of a digital agenda uploaded and posted to the Agenda Center of the Lee County website for dates March 7th, 2024, April 3rd, April 4th, and April 10th. Subsection B, posting the agenda on the County Board Chairman's Bulletin Board in the Old Lee County Courthouse on February 23rd, 2024, the March 7th, 2024 agenda, and March 21st, 2024, the April 3rd, 4th, and 10th, 2024 agendas. And C, a timely notice was posted as noted in Zoning Officer Exhibit 4 at the southwest corner of the parcel identified as 16-01-35-400-009 on February 20th, 2024.
I make-
Move for approval.
I second.
We have a motion and a second. Is there any discussion? Hearing none. All in favor, say aye.
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 Subsection 1D, initial session. On the evening of Wednesday, April 3rd, 2024, the public hearing beginning at 6 p.m. was initially announced by ZBA Chairman Bruce Forster in the former courtroom on the 3rd floor of the Old Lee County Courthouse. Subsection D2, under the authority provided by its own rules, prior to formally initiating the hearing, the ZBA engaged the services of attorney Timothy Zollinger to serve as the facilitator for the proceedings, also known as the facilitator.
Make a motion to approve these statements.
Second.
We have a motion and a second. Is there any discussion? Hearing none. All in favor, say aye.
Aye.
Aye. All opposed? Motion carries.
Next section is subsection E, entitled Process. Number 1, E1, the Lee County ZBA finds that the public hearing began on April 3rd, 2024, and concluded on April 4th, 2024, after approximately 5.5 total hours of hearing time. Subsection 2, the Lee County ZBA finds A, through the auspices of the Lee County IT Department and Lee County Zoning and Planning Officer, interested parties were provided the opportunity to participate in the hearing remotely and virtually by either video or teleconferencing via the video communication platform Zoom, using a computer, telephone, or similar communication device at a location of their choosing. 2B, the Lee County ZBA finds at any given time there are approximately 14 interested parties that appeared in person and 3 persons on Zoom. C, interested parties could always remotely view and listen to the proceedings in near real time or later in the recorded mode on a YouTube feed, and there were no technical interruptions. D, due to an issue with the elevator in the old Lee County Courthouse, a secondary location was established by county officials on the first floor of the courthouse, at which location any interested party could see, observe, and participate if requested. No such party requested or utilized the secondary location. For the record, I see none this evening either. E, interested parties can rewatch the hearing, which was recorded and uploaded to the Lee County account on YouTube. F, the entirety of the hearing proceedings was taken down by a certified shorthand reporter and subsequently transcribed. Transcripts of all testimony, arguments, public comments, and ZBA discussion will be available on the Lee County Zoning and Planning web pages found on the Lee County website. Subsection E3, the Lee County ZBA finds that over the course of the first stage in the public hearing, everyone, including the petitioner and interested parties, were given a complete and fair opportunity to be heard. 4, the Lee County ZBA finds that everyone, including the petitioner and interested parties, were given the chance to present evidence, including witnesses and exhibits, cross-examine the witnesses of others, and to present a closing argument, statement, or public comment. 5, prior to hearing, written comments and objection to the project were received from Palmyra Township, identified as Zoning Office Exhibit 7, and Brenda and Gerald Winger, identified as Zoning Office Exhibit 8, were both received. 6, at the conclusion of the hearing, 2 individuals, Dennis Boynton and Dr. Sarah Willie, requested the opportunity to submit written comments to the zoning board and was permitted by the hearing facilitator to do so. 7, excuse me, at the conclusion of the hearing, Dennis Boynton did submit written comment, and Dr. Sarah Willie requested to submit her written comment to the zoning board and was permitted by the hearing facilitator to do so by the deadline of April 10th, 2024. 8, during the ZBA hearing, all interested parties that desired to comment were permitted to do so. Several interested parties spoke in opposition to the project. No interested party witness spoke in favor of the project.
I move to approve section 1E.
Second.
We have a motion and a second. Is there any commentary on this one?
So the number 7, we're saying that Dennis Boynton and Sarah Willie submitted written and was permitted by the hearing facilitator.
That's correct.
But then,
Mr. Boynton submitted his that evening after the conclusion of the public hearing. I don't know the exact date Dr. Willie submitted hers, but it was by today.
but where I was going with what you said earlier then is because of this statement that before the hearing started, that
I wanted to make sure we acknowledged that Dr. Willie was permitted to do so. She did in fact do so. Those documents are available.
but
comments.
any subsequent material is not presented as evidence.
Any additional information beyond those 2 individuals that was submitted after closure of the public hearing is available in the zoning office, but it's not part of the evidentiary record. and you, the members of the zoning board, can give it whatever weight you believe it's entitled.
Correct. That's my understanding
Yeah.
also. Okay.
So back to the question. Any other comments? All in favor, say aye.
All right.
Aye.
All opposed? Motion carries.
Section 1F is entitled Witnesses. The ZBA finds that 3 individuals took the witness stand, were placed under oath or affirmation, and testified. Interested parties who spoke on the topic without testifying as a witness were also allowed to offer comments. Sworn witnesses in order of appearance, including a summary of their testimony, were as follows. Number 1, Ms. Alice Hinkle, Lee County Zoning and Planning Administrator, laid the foundation for the admission of her and Lee County's exhibits into evidence. These exhibits included the various notice processes for the ZBA hearing and the assorted documents accepted and kept within her office. She further testified that the petitioner had supplied all the necessary documents, reports, and materials necessary to comply with the Lee County Solar Ordinance, Ordinance Number 2023-07008, and the applicable sections of the Lee County Code, and the petitioner's application materials were complete. Alice Hinkle further testified to the written comments that were received by the zoning office. Subsection 2, Mr. Keith Morrell appeared on behalf of the petitioner. He is a project developer with Ironwood Renewable, appearing on behalf of Pulse Solar 2 LLC, a wholly owned subsidiary of Ironwood. He outlined his experience with development of community solar projects for the past 4 years, as well as with regulatory compliance, site acquisition, and outreach with landowners. He went on to provide explanation of the site being selected due to the immediate available ComEd interconnection. Mr. Morrell also provided overview and information related to the ground lease agreement, SHPO letter from the Illinois Department of Natural Resources, the AMA, vegetative screening, and land value reports. Number 3, Mr. Michael Maroos, president of Maroos and Company, appeared on behalf of the petitioner. He is the president and licensed general certified appraiser in the state of Illinois. He testified to his background and steps taken to provide opinions on the lack of impact on real estate valuation of surrounding properties based on the proposed siting of the commercial solar energy facility. He testified that a page in his original report was wrongfully calculated and provided a corrected page, admitted as petitioner's Exhibit 7. He also offered his opinion that siting of this project would have no or minimal, identified as less than 1.5%, impact on the surrounding properties. He provided input on the relevant peer-reviewed studies relating to solar energy facilities and valuation of surrounding property. Number 4, there were no other sworn witnesses. Number 5, interested parties spoke about their opposition to the project. Interested parties were permitted to ask questions of the 3 witnesses and actively did so. One interested party, Wendy Willett, offered the playing of a recording without evidentiary foundation, asserting that it was her opinion of what was played was the noise level likely heard at her property line emanating from the solar array. 2 interested parties actively participated remotely, offering comments in opposition and posing questions. No limits were placed on the comments of interested parties.
I move for approval.
Second.
We have a motion and a second. Is there any discussion on this section? Hearing none. All in favor, say aye.
Aye.
Aye. All opposed? Motion carries.
Next section is G, labeled exhibits. The ZBA finds that the following exhibits were admitted in evidence after inviting all parties to note any objections by the facilitator and considered by the ZBA. Number 1, petitioner's exhibits. Petitioner's exhibit number 1 was a Lee County special use permit application with appendix A through U. B, petitioner's exhibit number 2 was the ground lease agreement with Matthew and Bernadette Hermes. C, petitioner's exhibit number 3 was the SHPO letter dated March 13th, 2024 from the Illinois Department of Natural Resources. D, petitioner's exhibit number 4 was the executed agricultural impact mitigation agreement. E, petitioner's exhibit number 5 was the vegetative screening site plans. F, petitioner's exhibit number 6 was the land value report generated by Maroos and Company. And petitioner's exhibit number 7 was Maroos and Company's corrected summary of residential sales nearest to Pulse Solar 2 LLC location.
I move to approve section G.
Second.
We have a motion and a second. Is there any comment? Hearing none. All in favor, say aye.
Aye.
All opposed? Motion carries.
Next section is H, zoning officer exhibits. Number H1, zoning officers group exhibit number 1 was a copy of the file stamp petition for special use permit filed on February 2nd, 2024. Number 2, H2, zoning officers group exhibit number 2 was a copy of the notice of public hearing sent to various Lee County agencies regarding the project, including District 4 County Board members, the Lee County Health Department, the Lee County Soil and Water Conservation District, the City of Dixon, the City of Dixon Planning Commission, the Palmyra Township Supervisor, and Palmyra Township Road Commissioner. 3, zoning officers exhibit number 3, a copy of the agenda posted for the hearing and sessions of the ZBA, including March 7th, April 3rd, April 4th, and April 10th, 2024. Subsection 4, zoning officers exhibit 4 was a copy of the notice of public hearing posted. Number 5, zoning officers exhibit number 5 was a copy of the notice of public hearing sent by certified mail and the return receipts of same mailed to adjacent property owners adjacent to the development, and a copy of the Dixon Telegraph certificate of publication and the notice of public hearing. Number 6, zoning officers exhibit 6 was a copy of the Lee County Soil and Water Conservation District's Natural Resources Information Report dated March 6, 2024. And 7, zoning officers exhibit number 7 was a letter of objection from Palmyra Township dated March 14, 2024, and a copy of the finding of fact by Palmyra Township Planning Commission dated March 11, 2024. And number 8, zoning officers exhibit number 8, letter of objection from Brenda and Gerald Winger.
I make a motion to approve these statements.
Second.
We have a motion and a second. Do we have any further comments? Hearing none. All in favor, say aye.
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 All opposed? Motion carries.
Next section is J, interested party exhibit. Subsection A, no formal exhibits were offered as evidence by any interested party. 2 interested parties, Dennis Boynton and Dr. Sarah Willie, offered submission of written documents requesting that they be attached to the record. No objection was offered as to these items being made part of the record.
I make a motion to approve.
Second.
We have a motion and a second. Is there any discussion? Hearing none. All in favor, say aye.
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 Aye. All opposed? Motion carries.
Next section is K, closing statements, public comments. The ZBA finds that the following individuals and interested parties were permitted without limitation the opportunity to make closing statements or public comments. Number 1, K1, counsel for petitioner, Ms. Courtney Kennedy, used the content of the exhibits, supporting materials, and hearing factors set forth in the Lee County ordinance to explain and demonstrate the project's compliance with the Lee County ordinance, and stated the reasons the ZBA should recommend to the Lee County Board to approve the petition for a special use permit. Number 2, interested parties were permitted without limitation to offer comments and ask questions of the witnesses. These individuals included Dr. Sarah Willie, Dennis Boynton, John Delgado, Wendy Willett, Dr. Joyce Johnson, Sean Foster, Kim Stanley, and Dory Kingery. This also included individuals who attended remotely, namely Dave Stanley. The ZBA further finds that the testimony offered by each witness, sworn witness, is fairly and accurately reflected in the transcript of proceedings taken by the court reporter at the public hearing. The transcript of proceedings are formally adopted herein.
I move to approve section K.
Second.
We have a motion and a second. Any discussion? Hearing none. All in favor, say aye.
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 Aye. All opposed? Motion carries.
Next section is L, overview of development. Based on the exhibits offered at public hearing and testimony of the witnesses, including the project developer, the ZBA finds that, number 1, purpose, the petition seeks issuance of a special use permit, SUP, SUP, permitting construction of a 5-megawatt commercial solar energy facility with accompanying battery energy storage system, or BESS. 2, useful life, The anticipated lifespan of the type of panels to be used in construction is warranted to be up to 25 years with an expected lifespan of approximately 40 years. 3, components. The equipment specifications to be used in the project were explained by petitioner's witnesses and reflected in petitioner's Exhibit Number 1, Subappendix B. 4, access road and fencing. That based on the petition, testimony of the petitioner's representative, the access points will be new lanes constructed on or within the project site. Based on the testimony of the petitioner's representative, the fencing surrounding the project will be 6 feet in height and constructed with components that will allow small wildlife to enter and exit the project site unabated. Number 5, background findings. That based on the testimony of the petitioner and the documents submitted with the application, there appear to be no protected lands identified by the Illinois Department of Natural Resources. No adverse findings were issued by the Illinois State Historic Preservation Office. No adverse findings were issued by U.S. Fish and Wildlife. Number 6, community opposition. Palmyra Township voted at a public meeting to oppose the petition. A copy of the letter of opposition and findings from the Township Planning Commission were admitted without objection. The zoning office Exhibit Number 7.
I move for approval.
Second.
We have a motion and a second for approval. Do we have any discussion? Hearing none. All in favor, say aye.
Aye.
Aye. All opposed? Motion carries.
Next section, labeled 3, applicable ordinance. The specific, subsection A, the specific Lee County CSEF ordinance on July 20, 2023, the Lee County Board Chairman signed into law an ordinance amending the regulating development of commercial solar energy facilities. The ordinance passed by the county board is ordinance number 2023-07008, which would then be the provision specifically applicable to the petition at issue, which has been codified. Subsection B, rules and regulations pertaining to standalone battery energy storage systems, or BESS. At the time of the filing of the petition, the Lee County Board, I think there's a typo here. It should say did not have an ordinance in effect prohibiting standalone BESS. The code, however, defines supporting facilities as transmission lines, substations, access roads, storage containers, and equipment associated with the generation and storage of electricity by the commercial solar energy facility. Furthermore, the ordinance defines commercial solar energy building permit as a permit necessary for the commencement of work performed towards the construction, erection, or installation of an approved commercial solar energy facility, substation, supporting facilities, or operations and maintenance building in connection with a commercial solar energy facility. Subsection C, other applicable ordinances. The ZBA finds that also in place at the time of the petition and continuing thereafter, certain provisions of the Lee County ordinance, quote, performance standards and, quote, special exceptions, variations, and nonconforming uses remain applicable to the petition unless expressly supplanted by the Solar Energy System Ordinance 2023-07008.
Make a motion to approve these.
Second.
We have a motion and a second. Any discussion?
I have a question for either Charlie or Alice. On the standalone battery energy storage system, did we or did we not have an ordinance in effect at the time of the petition, and do we now?
That is correct. There is no ordinance prohibiting this.
Then or now or both?
Both,
Not for a standalone?
not for standalone.
Okay. And there isn't for an accessory one either then?
Correct.
But we're
Okay.
of the opinion that it's part of the facilities.
This one is, but
That's,
but there isn't an ordinance against the standalone anyway.
no, but we're saying that in our ordinance, we're saying that it is part of the supporting facilities.
Right, I believe in your code, in the county's code, supporting facilities include things such as transmission lines, substations, access roads, storage containers, and equipment. So, and
Right.
equipment associated with the generation and storage of electricity.
That's what I'm asking everybody.
Storage of electricity.
Everybody
Yeah.
agrees with that opinion.
Isn't that the way the state laws stated also?
Correct.
I don't have any other questions.
No other discussion? All in favor, say aye.
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 All opposed? Motion carries.
So the next section 4 is entitled Evidentiary Findings of Fact Required by the Lee County Ordinance. After duly considering the content of the application, supporting documents, reflecting on the testimony and exhibits presented at public hearing, let's say reflecting on the sworn testimony, sorry, typo there. Sworn testimony and exhibits presented at public hearing, the members of the ZBA hereby find, A, the petitioner will, at the time of application for the building permit, have a structural engineer certify that the commercial solar energy facility is within accepted professional standards and compliant with all state and county code requirements.
Move to approve section 4A.
Second.
We have a motion and a second. Any discussion? Hearing none. All in favor, say aye.
Aye.
Aye. All opposed? Motion carries.
4B reads, the petitioner demonstrated that no component of the project will exceed 20 feet in height above the ground at full tilt.
I move for approval.
Second.
Any discussion? Hearing none. All in favor, say aye.
Aye.
Aye. All opposed? Motion carries.
4C reads, the petitioner committed to adhering to the vegetative screening requirements as set forth in the ordinance and further provided site plans that demonstrated the proposed vegetative screening for the project.
Move to approve 4C.
Second.
We have a motion and a second. Do we have any discussion? Hearing none. All in favor, say aye.
Aye.
All opposed? Motion carries.
D, the petitioner testified that no lighting will be utilized for the project. However, in the event that any lighting is required by a condition of the Lee County Board, petitioner committed that all lighting will be shielded and downcast and be dark sky certified lighting.
Move to approve section D.
Second.
We have a motion and a second. Do we hear any discussion on this one? Hearing none. All in favor, say aye.
Aye.
Aye. All opposed? Motion carries.
Subsection E, the petitioner confirmed that all power lines used to collect power and all communication lines shall be buried underground to the greatest extent possible in accordance with the AMA.
I move for approval.
Second.
We have a motion and a second. Any discussion on this one? Hearing none. All in favor, say aye.
Aye.
Aye. All opposed? Motion carries.
4F, petitioner testified that the fence shall have a minimum height of 6 feet and be installed, maintained, and secured around the project in compliance with the National Electric Code, the NEC, and shall contain appropriate warning signage that is in accordance with the NESC and ANSI Z5 535 safety sign standards and OSHA regulations. In addition, the fence will be comprised of woven wire fixed knotting and would allow a 6-inch gap along the bottom of the fence so as to prevent the restriction of wildlife movement according to the IDNR recommendations.
Move to approve 4F.
Second.
We have a motion and a second. Is there any discussion?
So I got in my notes that they said it would be 8 foot tall. Did we have a maximum height, or you guys remember? I mean, he has a minimum height of 6 foot. I mean, we don't ever have a maximum height, do we?
No. But I don't,
I'm just asking. I'm just asking if anybody else remembered that statement.
Does the ZBA want to amend this finding to provide minimum height of 6 feet testified by petitioner to be 8 feet?
Well, that's in my
I
notes.
don't remember what
Yeah, I
the
don't.
petitioner testified. I really don't.
Okay.
I remember, I thought I heard 8, but I wasn't sure, and that's why I used to mention that Mike brought it back to mind, but
I thought the fence was 6 and the vegetation was 8
8.
within 3 years. That was my recollection.
Okay, that's fine. I'm just asking.
So we have a motion and a second. Any further discussion? Hearing none. All in favor, say aye.
Aye.
Aye. All opposed? Motion carries.
Next section is G. The petitioner committed that all warning signage concerning voltage will be in accordance with NESC and ANSI Z535 safety sign standards and OSHA regulations, and will be placed at the base of all pad mounted transformers and to the extent present, and substations and at all entrances to the project.
Move to approve 4G.
Second.
We have a motion and a second. Is there any discussion on this one? Hearing none. All in favor, say aye.
Aye.
Aye. All opposed? Motion carries.
Next section is H. The petitioner confirmed that visible, reflective, and colored objects such as flags, plastic sleeves, reflectors, or tape will be placed on anchor points of all guy wires and along the guy wires up to a height of 15 feet from the ground.
Move for approval.
Second.
We have a motion and a second. Is there any discussion on this one? Hearing none. All in favor, say aye.
Aye.
Aye. All opposed? Motion carries.
Next section is I. The petitioner confirmed through testimony in the site plans presented that the project would adhere to all setback requirements of the ordinance.
Move to approve section 4I.
Second.
We have a motion and a second. Is there any discussion? Hearing none. All in favor, say aye. Aye. All opposed? Motion carries.
Next section is J. While interested parties suggested the petitioner should consent to setback requirements in excess of the ordinance and state statute as proposed in pending legislation, there is nothing in the ordinance that allows the ZBA to compel or request the same.
Move to approve 4J.
Second.
Is there any discussion? Because we did discuss this during the meeting too. So
During what meeting?
when we were having when it was going on here.
Well, I was just, that last statement, I just want to talk about it a little bit. I don't know what my opinion is, other than it states there is nothing in the ordinance that allows the ZBA to compel or request the same. That may be true, there's nothing in there, but does that stop us from doing that?
I don't think it stops us. I think but I think it would only be that we could potentially make a recommendation. That would be all.
In days past, when there was home rule or local rule on zoning, we would have clearly probably put the setback more, but I don't see, if we do make a recommendation, that the county board won't approve our recommendation. I think this is a fact.
That there's something in the ordinance that says that we can't make a suggestion? Or to compel, I guess, or request. I guess that's a suggestion, the request.
Now, the words here could certainly be those chosen by the members of the zoning board. The concept of this finding is that the county ordinance and the state statute set the setback requirement. While you could encourage, recommend, but the setback requirement is set by the county code and the state statute. So there is no authority to compel the petitioner to do something different. I would defer to your state's attorney on the legal side of that, but I believe that's what the state statute
That's what I'm
says.
doing.
I agree with what Mr. Zonder is saying, and I would encourage you to follow the law and make sure that you are not exceeding the standards that are set out with the ordinance or the state statute.
But does it say that we cannot request in the ordinance? I don't remember that ever being, whether that was added in the new ordinance. I don't ever remember that we couldn't even request. I guess that's my question on this statement.
So what it says that there's nothing within the ordinance that allows the ZBA to compel. You cannot compel the petitioner to be more restrictive, nor can you request the same if they are not agreeing to do so.
Yes, that one word is my problem, request.
And you can certainly amend that. You can just, you cannot compel.
Hmm.
And I guess the other point would be you could not request it as a condition of issuance of any special use permit.
Say that again.
It can't be a condition that the additional setback is required because that would be in conflict with state law and your county code.
And that's part of the change that has happened.
When the legislature changed the state statute, that's correct.
Okay.
Again, you can pick a different word. It's not meant to
Yeah.
bind you in some way. It's meant to
I-
reflect.
Like I say, I'm throwing this out. I don't have an answer here. I'm just wanting discussion. So. He's the ultimate decision maker here beyond us. So I guess I would like to just leave that, just stop at compel and leave out request. There's nothing in the ordinance that allows the ZBA to compel the same.
And these are certainly your findings to make, and you can make whatever amendments you would like to make to those findings. My job is just to give you legal assistance and represent you
Right.
in any event.
So if you wish to amend the finding, then the person who made the motion can accept the amendment, or you can move to amend the finding. Either way.
Well, I guess I'd like to suggest leaving request
To eliminate those words.
or request out, eliminate them two words.
So in that context, does I don't remember who made the motion, does you accept that amendment to strike those words from the finding?
Did I make the motion or did Craig?
I think you
You
did.
made the motion.
I'm willing to amend that by deleting those two words.
And the person who made the second accepted as well?
Yes.
So the motion's been amended and agreed to by the mover and the second. And that's now the motion finding striking the words or request would be the finding.
I move for approval of that amended statement.
Second,
What was that?
Jay.
Jay? I move to accept the statement J.
So
As
that-
amended?
So that one will now
That is
read,
the statement now.
Okay.
yeah, that one will now read, while interested parties suggested that petitioner should consent to setback requirements in excess of the ordinance and state statute as proposed in pending legislation, there is nothing in the ordinance that allows the ZBA to compel the same.
Correct.
Okay. Okay, is that the end of the discussion? So, all in favor of the amended motion, say aye.
All right.
Aye.
Aye. All opposed? Motion carries.
Subsection K, the petitioner committed through testimony to entering into a road use agreement with the county engineer in any applicable township.
So approved.
Second.
We have a motion and a second. Is there any discussion on that one? Hearing none. All in favor, say aye.
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 All opposed? Motion carries.
Subsection L, petitioner committed to depositing the requisite funds into the consulting fund as required by the ordinance.
I move to approve that.
Second.
We have a motion and a second to approve. Is there any discussion on that one? Hearing none. All in favor, say aye.
Aye.
All opposed? Motion carries.
Next section is M, the petitioner committed to providing additional comprehensive soil and geotechnical boring reports at its expense to the Lee County engineer.
Move for approval.
Second.
We have a motion and a second. Is there any discussion on this? Hearing none. All in favor, say aye.
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 Aye. All opposed? Motion carries.
Next section is N, the petitioner committed to following the guidelines for conservation practices, impact mitigation as provided by the Lee County Soil and Water Conservation District, LCSWCD.
I move for approval.
Second.
We have a motion and a second. Is there any discussion on this? Hearing none. All in favor, say aye.
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 Aye. All opposed? Motion carries.
Next section is O, the petitioner supplied a noise analysis study prepared by Krebs and Lansing, a consulting engineering firm, which indicated that noise levels generated by the project will not exceed the standards set forth by the Illinois Pollution Control Board.
I move to approve section O.
Second.
We have a motion and a second for section O. Is there any discussion? Hearing none. All in favor, say aye.
Aye.
Aye. All opposed? Motion carries.
Next section is P, the petitioner supplied a glare analysis performed by Forge Solar. It concluded that no glare is predicted in association with the project.
Move for approval.
Second.
We have a motion and a second. Any discussion on this one? Hearing none. All in favor, say aye.
Aye.
Aye. All opposed? Motion carries.
Q, the petitioner supplied a SHUPO SHPO letter from the Illinois Department of Natural Resources dated March 13, 2024. Excuse me, they concluded that the IDNR did not identify any known historic properties within the proposed project area, and that the project area is not within the high probability area for archaeological resources as defined in the Illinois State Agency Historic Resources Preservation Act.
Move to approve section Q.
Second.
We have motion and a second. Is there any discussion on this one? Hearing none. All in favor, say aye.
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 All opposed? Motion carries.
Next section is R. The petitioner supplied the results of a wetland delineation performed by Atwell that confirmed that no wetlands were delineated within the project site.
Move for approval.
Second.
We have a motion and a second. Is there any discussion? Hearing none. All in favor, say aye.
Aye.
Aye. All opposed? Motion carries.
Next section is S. The petitioner supplied an executed agricultural impact mitigation agreement with the Illinois Department of Agriculture.
Move for approval.
Second.
We have a motion and a second. Any discussion? Hearing none. All in favor, say aye.
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 Aye. All opposed? Motion carries.
Next section is T. The petitioner committed to providing as-built maps, site plans, and engineering plans for the project to the Lee County Zoning Administrator and Lee County Supervisor of Assessments within 60 calendar days of completion of construction.
Move for approval.
Second.
We have a motion for approval and a second. Is there any discussion? Hearing none. All in favor, say aye.
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 All opposed? Motion carries.
Next section is U. The petitioner provided an engineer's certificate that the specific soils and subsurface conditions at the site can support the apparatus, given local soil, subsurface, and climate conditions. Moreover, the petitioner committed to providing updated engineering certificates confirming same prior to the application of a building permit.
Move to approve section U.
Second?
We have a motion and a second. Is there any discussion? Hearing none. All in favor, say aye.
Aye.
Aye. All opposed, motion carries.
Next section is V. The petitioner confirmed that will only utilize the project site for the storage of materials, vehicles, and equipment for the direct support of the operation and maintenance of the project.
I move for approval.
Second?
We have a motion and a second. Is there any discussion? Hearing none. All in favor, say aye.
Aye.
All opposed, motion carries.
Next section is W. The petitioner confirmed that during construction of the project, construction activities shall commence no earlier than 7 a.m. and shall be discontinued no later than 8 p.m.
Move for approval.
Second.
We have a motion and a second. Any discussion? Hearing none. All in favor, say aye.
Aye.
All opposed, motion carries.
Next section is X. Petitioner committed to submit a copy of the site plan, standard operating procedures, and standard operating guidelines for the project to local emergency responders prior to applying for a building permit. The petitioner further committed to providing annual training for and the necessary equipment to local emergency response authorities and their personnel.
Move to approve section X.
Second?
We have a motion and a second. Any discussion on this one? Hearing none. All in favor, say aye.
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 All opposed, motion carries.
Next section is Y. The petitioner committed to removing all solid waste related to the construction, operation, maintenance of the project promptly and to dispose of the same in compliance with all federal, state, and local laws.
I move for approval of section Y.
Second.
We have a motion and a second. Any discussion? Hearing none. All in favor, say aye.
Aye.
All opposed, motion carries.
Next section is Z. The petitioner testified that no hazardous materials will be stored on site other than as may be contained within the self-contained BES unit.
Move for approval.
Second.
We have a motion and a second. Is there any discussion on this one? Hearing none. All in favor, say aye.
Aye.
All opposed, motion carries.
Next yes.
So I would like to add one more. And I don't know where it's appropriate, other than maybe just now. I'd like to say that the petitioner testified that they did not know the soil productivity rating.
Second.
Well, I don't know. It depends
So
where he
I
wants to
think
put it.
our the draft that we're working on has findings through LL, so we're going to call this MM.
That's fine. That's fine. I didn't know where you'd want it.
That's fine.
Yeah.
Petitioner did not know, restate.
The petitioner testified that they did not know the soil productivity index number.
Okay?
Did we have a motion for that, or do we?
I believe he made a motion. I've not
Second.
heard a second yet.
And we have a second.
Okay.
And that's MM.
We'll refer to that one as MM when we have the final signed
Okay.
copy.
All right. Any further discussion on that one? Hearing none. All in favor, say aye.
Aye.
All opposed, motion carries.
So we'll go back, so now we're on double A. The petitioner committed to maintain with the Lee County Zoning Administrator and Lee County Sheriff's Department a primary point of contact with 2 secondary points of contact.
Move to approve double A.
Second.
We have a motion and a second. Any discussion? Hearing none. All in favor, say aye.
Aye.
All opposed, motion carries.
Next section is double B. The petitioner committed to repairing at its expense in a prompt and timely manner all waterways, drainage ditches, agricultural drainage systems, field tiles, and any other private or public infrastructure improvements that are damaged during the construction, maintenance, and operational phase of the project in accordance with the AMA.
I move for approval of BB.
Second.
We have a motion and a second. Is there any discussion on this one? Hearing none. All in favor, say aye.
Aye.
All opposed, motion carries.
Next section is double C. The petitioner committed to adhere to all liability insurance and indemnification requirements as set forth in Article 7 of the ordinance.
Move to approve.
Second.
We have a motion and a second. Any discussion? Hearing none. All in favor, say aye. All opposed, motion carries.
So before we get to the next few, one of the things the members of the zoning board may consider, you may consider noting that at this time, the zoning board, the ZBA affirmably notes that it is duly considered the testimony of the witnesses sworn in and whom offered testimony. All exhibits had been in evidence during the public hearing. Interested parties provided comment asserting that approving the project would be detrimental to the valuation of their properties and disrupt the pastoral setting of their subdivision. The ZBA has duly considered all of this information and the totality of all information presented before the ZBA. The ZBA has duly considered the provisions of the county ordinance and applicable state statute relative to commercial solar energy facilities. And based on this, we now move into DD, that the establishment, maintenance, or operation of the proposed project, the commercial solar energy facility, will not be detrimental to or endanger the public health, safety, morals, comfort, or general welfare.
Move to approve double D.
Second.
We have a motion and a second. We have any discussion?
I got a question again. It says the commercial solar energy facility. Should it be called a community solar energy facility?
I would defer to your state's attorney how you prefer. I believe they end up being one and the same under the code because a community solar would be a commercial solar as well.
But this is a community solar, the one we're dealing with here.
I agree with what Mr. Zollinger's saying. It's one and the same.
If the members of the ZBA would prefer to use the word community, that you may certainly do that. That's your finding.
You can say it's a community commercial solar.
Well, no, he uses it several more times here, and I just didn't know whether that was something that,
I prefer commercial because it is commercial.
okay, that's fine.
Well, this one is not getting subscribers in because they didn't mention anything about
Oh,
it.
I think it is.
I think it is a community solar.
Well, I know if they're community, they're supposed to be there. I don't recall him mentioning anything about subscribers.
It's just, it's, you know, it's not important, but I just,
Well,
Again, whatever the members of the zoning board are comfortable referring to it as. I believe in the record, there was some reference to community and subscribers. Subscribers aren't always local. The community could be individuals in many other places.
Correct.
I think there was comments from the interested parties that none of the adjacent property owners had enrolled or subscribed.
oh, yeah.
So we're leaving it the way it is?
that's fine with me. I just want to bring it up.
Okay. We have a motion and a second. We've had discussion. So all in favor, say aye.
All right,
Aye. All opposed? Motion carries.
Next section is double E. The project, the commercial solar energy facility, will not be injurious to the uses and enjoyment of other property in the immediate vicinity for the purposes already permitted. nor substantially diminish or impair property values of surrounding properties.
I move for approval. I have to get my motion so we can discuss it.
A second.
Okay, we have a motion and a second. Is there discussion?
Well, the statement is debatable.
So to help the members, maybe the ZBA, the petitioner offered the testimony of their appraiser regarding the valuation. In the first night of the hearing, there was various comments on cross-examination about the content of that report and comments noted about errors. In the second night of the hearing, the appraiser testified, acknowledged his errors, and offered a corrected sheet, which was admitted into evidence. Various interested parties did offer their perspective or comment that they felt this project would be injurious to their property values. So their comments may certainly be considered by the members of the ZBA for the weight that that has. So that's the point you would discuss here.
We've dealt with, I don't know how many different solar farms, and we've had this testimony for every one of them. In fact, Mr. Maroos has testified at other ones too, so we're pretty familiar with this type of discussion.
But it's still an opinion.
Oh, yeah.
It is.
But it's an opinion on both sides too.
Yeah.
Correct. Correct. So it
But
becomes-
this is our finding.
Yeah, so it still comes down to our opinion of the opinion.
Right.
And it does say nor substantially diminish. Or impair. The word substantially qualifies that quite a bit.
So what substantially mean? Less than 5%?
Well, there was discussion of 1.5%. There was discussion of 3%.
Yeah.
That can change with interest rates.
Well, you know,
It can change with anything. So,
Do we even have to
say anything.
say anything about this? Do we have to determine that one way or the other?
Certainly, the members of the ZBA can choose to make a finding or not make a finding. That is your decision to make. This is one of the findings or requirements in the code that you would normally address in making your ultimate recommendation to the county board.
Explain that a little better.
If you look in the county code, this is one of the, in the state statute, this is one of the factors that would be applied. So it would be one of the factors that you're being asked as the ZBA to opine on or make a finding on when this matter then goes to the county board.
This is one of those 5 questions we always had to answer.
Yeah.
You know, and
In the past, we've said we cannot find that it will not substantially diminish the value.
We cannot find that it will not substantially. Which means what to you?
Which means it wasn't proven that it won't
Right.
diminish the value.
Right. And that's kind of where I'm falling on this. Is I'm not sure we were proven one way or the other.
Yeah, I would say there's certainly doubt on both sides. When the appraiser comes in and tells me it's going to increase the value of the properties next to it, I always take that with a grain of salt. I don't think Mr. Morose did that this time, but in the past that we've heard that testimony.
I'm just wondering how we could restate this somehow, but I'm not sure that solves the problem.
One alternative would be a finding that indicates that the ZBA is unable to conclude whether the project, the commercial solar energy facility, will be injurious to the uses and enjoyment of other property in the immediate vicinity or substantially diminish, change it.
I like that.
You're
wordage.
unable to conclude either way.
I like that wordage, yes.
Yeah, I would like to make that change.
Yes.
Read that again then, so we can write it down.
So if you make that change, it would read, is unable to conclude whether the project, the commercial solar energy facility, will be injurious to the uses and enjoyment of other property in the immediate vicinity for the purposes already permitted or substantially diminish or impair property values of surrounding properties. Not saying that's how you have to say it, but that's based on your comments.
Yes, I make a motion to approve.
Second. Yeah, oh, the
Yes.
original one, yeah.
Well,
So do we
then,
need to vote down that first motion?
Well, he's offering an amendment.
Okay.
So I believe someone would make a motion to accept the amendment, and then you can vote on the finding as amended.
so you're saying I need to make a motion to amend?
Correct, the proposed finding. That would be seconded, then voted on, and then you would vote again on the finding as amended.
I make a motion
Does that meet your,
to amend the motion that's on the table.
I second it.
Okay. We have a motion to amend in a second. And we've had a lot of discussion. So all in favor of the amendment, say aye.
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 All opposed? Motion carries.
and we still go back to double E as now amended as a finding. So someone would need to approve the amended finding.
I move to approve the amended finding.
I second.
Okay. We have a motion and a second to approve the amended finding. All in favor, say aye.
Aye.
All opposed? Motion carries.
Next is double F, establishment of the commercial solar energy facility will not impede the normal and orderly development and improvement of the surrounding properties.
So move.
Second.
Okay. We have a motion and a second. Is there any discussion on this one?
In this case, when we're looking at surrounding properties, we've got the subdivision to the west and then basically the ag zoning on
Right.
the other sides.
Yes. Any other discussion? Comments? Are you contemplating still?
I was thinking if the other property's not developed, the ag property, then we're not going to impede the development if there's not going to be development, so.
Right. Okay. So, all in favor, say aye.
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 Aye. All opposed? Motion carries.
Double G, adequate measures have been or will be taken to provide ingress and egress, so signed to minimize traffic congestion on the public streets.
I move to approve double G.
Second.
We have a motion and a second. Any discussion on this one? Hearing none. All in favor, say aye.
Aye.
Aye. All opposed? Motion carries.
Next is double H, the proposed project, based on its proposed siting, is not contrary to the objectives of the current comprehensive plan of the county, as it is a recognized use for farmland.
I move for approval of HH.
Second.
We have a motion and a second. Is there any discussion on this? Hearing none. All in favor, say aye.
Aye.
Aye. All opposed? Motion carries.
Next one is double I, petitioner agrees to maintain appropriate approved decommissioning obligations within the land lease agreements and maintain compliance with the AMA and all county requirements.
Move for approval.
Second.
We have a motion and a second. Is there any discussion on this one? Hearing none. All in favor, say aye.
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 Aye. All opposed? Motion carries.
Next section is double J. Petitioner agrees to provide evidence of appropriate financial security with the Lee County Zoning and Planning Office prior to issuance of a building permit. All such financial security shall be updated at a minimum every 5 years.
I move for approval of JJ.
Second.
We have a motion and a second. Is there any discussion? Hearing none. All in favor, say aye.
Aye.
Aye. All opposed? Motion carries.
Next section is double K. The petitioner agrees to maintain a telephone or web-based portal permitting members of the public to notify petitioner of any issues and seek resolution. Petitioner shall maintain a log of such contacts and provide a copy of the same to Lee County Zoning and Planning Office upon reasonable request.
I move to approve double K.
Second.
We have a motion and a second. Any discussion on this? Hearing none. All in favor, say aye.
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 Aye. All opposed? Motion carries.
Next section is double L. Petitioner, petitioner at the time of issuance of any building permit shall submit a draft proposed emergency response plan relating to the BES, which shall have been prepared following input from fire protection agencies responsible for any emergency response. Petitioner shall update the plan following construction at a minimum of every 5 years or earlier if the BES equipment is substantially changed or replaced.
I move for approval of LIL.
Second.
We have a motion and a second. Any discussion? Hearing none. All in favor, say aye.
Aye.
Aye. All opposed? Motion carries.
Next section is 5, evidentiary findings of fact not directly addressed by any ordinance. 5A, vibration. The Lee County ZBA finds based on the material, typo in there, and testimony heard, other than probably construction activities such as truck traffic and sport pile driving, there would be no detectable vibration associated with this proposed development after completion. Subsection B, air pollution. The Lee County ZBA finds, based on the exhibits and testimony heard, that there would be no material or substance emitted from this proposed solar development. C, odor. The Lee County ZBA finds, based on the material and testimony heard, there would be no odor associated with the proposed solar development. D, electromagnetic fields. The Lee County ZBA finds, based on the testimony, there was no study conducted to determine what, if any, electromagnetic fields will be created by the proposed project. However, witnesses appearing on behalf of the petition project testified that there would be very minimal electromagnetic fields generated by the project, that the EMFs generated would be like the amount individuals encounter in everyday life, such as those generated from AC wiring or cell phones. Lee County ZBA therefore finds that there is no indication that any EMFs generated by the project would pose a threat to general welfare. E, heat. The Lee County ZBA finds, based on the petitioner's testimony, typo, material and testimony, there would not be significant heat associated with this solar development that would affect adjoining properties. F, fire and explosion hazards. The Lee County ZBA finds, based on the material and testimony heard, that there be no particular identifiable fire or explosion hazards associated with the proposed project. The ZBA does, however, make note of the presence of a proposed BES system and finds the petitioner's exhibits and testimony noted that heating and cooling measures would be in place to address maintenance of the BES, as well as presence of a fire suppression system.
Move to approve 5A through F.
Second.
We have a motion and a second. Is there any discussion on any of these? Hearing none. All in favor, say aye.
Aye.
Aye. All opposed? Motion carries.
Next section is tax revenue, jobs, economic advantages, and community benefits, section 6. The Lee County ZBA finds the petitioner testified the project would produce an increase in equalized assessed valuation. B, the Lee County ZBA finds that the proposed project would enhance greater electrical grid stability. C, the Lee County ZBA finds that the proposed project would contribute to the reduction of greenhouse gas emissions. D, the Lee County ZBA finds that the petitioner testified that the proposed development would not require any additional public services or utilities during construction or operation of the CSEF. accepting the use of roads and the possibility of emergency services. E, the Lee County ZBA finds that the participating landowner will financially benefit from the proposed project. F, the Lee County ZBA finds that the approval of this special use permit would not carry with it the need to access any traditional infrastructure or utilities other than that may be owned by ComEd. G, the Lee County ZBA finds that the project will generate an estimated 24 construction jobs. H, the Lee County ZBA finds that regardless of any economic benefit to the landowner or taxing districts within the county, its decision to recommend or not recommend approval of the petition is not based on any increase or decrease in revenue for taxing bodies, but rather the criteria in the Lee County ordinance and the project's compliance with the same.
I'll move for approval.
Second.
We have a motion and a second. Is there any discussion on this?
There's a couple of these that like C, we say that the Lee County ZBA finds that the proposed project would contribute to the reduction of greenhouse gas emissions. Maybe that should say that the petitioner testified that the proposed project. We find that the petitioner testified.
I agree
That's
with
not,
that.
that's not our finding, well, it's our finding that they testified to that.
Again, these are your findings, so whatever the members of the ZBA are comfortable with.
Well, that.
You could find, alternatively, you could find that the testimony was that, you could find that you conclude based on the type of project it is, namely solar, that any solar facility would in some manner reduce.
Yeah, I understand that, but I don't know if that's our job to make that determination. I think the petitioner should be testified to that. So.
All right, so that would be a proposed amendment to the finding for C. 6C.
I'll make that motion for that approval of that change, that amendment.
I second the amendment.
Okay. So what's the amendment say?
The amendment is to 6C. It would read, the Lee County ZBA finds that the petitioner testified the proposed project would contribute to the reduction of greenhouse gas emissions.
Okay.
The other letters or sub-paragraphs would stay the same.
Okay.
But right now, you would be voting on just the amendment to 6C.
Just the amendment on C. Okay. Is there any other discussion on that? Hearing none, all in favor say aye.
Aye.
Aye. All opposed? Motion carries.
Now you're back to the motion to approve section 6.
Yeah, now we got to go back for the full motion for the whole package.
I move to approve the amended 6A through H.
A second.
Okay, we have a motion and a second to approve the amended with what we did with C for the whole package. Is there any further discussion? Hearing none. All in favor say aye.
Aye.
Aye. All opposed? Motion carries.
Next section is section 7, binding pledges. The Lee County ZBA finds that a witness on behalf of Pulse Solar 2 LLC testified under oath or affirmation the following. A, the petitioner will be bound by all proposals, promises, statements, and representations in its materials for a special use permit, SUP, or made under oath at the public hearing before the Lee County ZBA, even if not expressly specified herein or therein. B, changes may be required as the development of the project continues. However, any changes will be in substantial accord with the petition and supporting materials. C, any successors and interests would be similarly bound as Pulse Solar 2 LLC, would make any sales subject to the terms and conditions of any special use permit granted to the project. D, the final decommissioning plan submitted at the time of actual construction and upon completion thereof will include and provide for removal of the battery energy storage or BESS. E, the ZBA finds that no variations from the applicable ordinance were requested by petitioner.
I move for approval of 7A through E.
Second.
Okay. We have a motion and a second. to approve. Do we have any further discussion? Hearing none. All in favor, say aye.
Aye.
All opposed? Motion carries.
Next section is 8, entitled Recommendations to the Lee County Board. After due consideration of the totality of the evidence presented at public hearing, as well as comments offered by interested parties at the public hearing, the ZBA finds the petitioner has provided evidence of compliance with all the requirements of the relevant Lee County ordinance, and as such is compelled to recommend to the Lee County Board that the petition of Pulse Solar 2 LLC for special use be approved.
I move to approve that recommendation to the Lee County Board.
Second.
We have a motion and a second. Is there any discussion on this?
The only discussion I have is that word compelled. I don't know about that word. I mean, my suggestion is required, but I don't know if that's even the right word. And this is a new time and era for us with this state statute.
So certainly if the members of the ZBA are uncomfortable, you could say something that simply says relevant Lee County ordinance and as such recommends to the Lee County Board. You could remove the word compelled. The context here would be your decisions are driven or constrained by the relevant Lee County code ordinance, as well as a state statute.
So is that your definition of compelled that we are?
Well, again, I'm not the attorney for the county, but I believe the concept for the ZBA is if a petitioner comes before you and meets all the requirements of the code, under what basis would you decline or be able to not recommend approval?
That's, I think, the area we're trying to figure out because we don't have much
We always
flexibility
said,
anymore.
we always said recommend before.
Yeah.
Right.
We
And you
could
can-
just take out, and it would go Lee County ordinance, and as such, recommends to the Lee County Board, and just take out the is compelled.
You can do that. And these are your findings. Again, the draft is to note for you folks, as members of the ZBA, that your role is to follow the code and what's required by the state statute and the code. If they've met those requirements, you know, what do you feel like you are? Do you feel like you're being forced to or compelled to? But certainly, these are your findings. So if you're more comfortable
That goes
removing,
back to my definition of compelled. What is your definition? Is that forced to? Is that what you mean by compelled?
that would be one way of looking at it. Yes.
Yeah.
Again, these are
I
your
don't
findings.
have a
not
problem
mine.
with the compelled in there, because I feel like we are, and we followed the hearing regulations, and these are the findings. They did meet the qualifications for being approved.
And that's what our job is to make sure that the petitioner followed what we have as a ordinance for the county.
So compelled is a nice way of saying forced to recommend to the Lee County Board. We could say as such is forced to recommend to the Lee County Board. That's a petition, right? So compelled is a
We have no
nicer
other-
word.
Compelled is much softer. I like it better.
Again, these are your findings. If you can want to remove the word compelled, that's up to you. They're your findings.
That's fine. I'm just throwing it out there again.
Are you happy with the word compelled?
I'm fine with it either way.
What about you, Craig? Give us a little discussion.
Well, that's in essence what it boils down to,
Right.
what we're doing.
Okay.
That's different from the past. That's what
Oh,
I
yeah.
wanted to bring up.
Right. No, I understand that. But we're different from the past because of the Illinois code.
That's right. Okay.
So, therefore,
Just
Okay.
embrace the change, Mike.
No.
so do we have a motion and a second? We have no amendment at this point.
Right.
We're going just forward. So we have a motion and a second. We've had discussion. All in favor, say aye.
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 Aye. All opposed? Motion carries.
Next section is 9, recommendations to the Lee County Board for conditions of the special use if petition approved. Excuse me, the ZBA recommends to the Lee County Board, if Pulse Solar 2 LLC's petition for special use is approved, that petitioner be reminded to comply with all provisions of the code, including but not limited to the following conditions, be approved as required by petitioner. A, road use agreement. Before any building permit is issued, the petitioner enter into a road use agreement relative to the proposed location, satisfactory to the county engineer, addressing construction activities not less than 30 days prior to issuance. B, interconnection agreement. Before any building permit is issued, a copy of the signed interconnection agreement with Commonwealth Edison be provided to the Lee County Zoning and Planning Office. C, fire protection matters. Based on the presence of a BEST, that the petitioner affirmatively meet with the respective identified first responder agencies to outline the nature of the system and receive written confirmation that the respective agencies have developed a satisfactory, appropriate response plan. D, permitted construction time. That a condition of construction be that construction activities shall commence no earlier than 7 a.m. and shall be discontinued no later than 8 p.m. absent written waiver of any affected non-participating resident, which in this case is they are all non-participating. E, drain tile survey. Before any building permit is issued, the petitioner undertake a drain tile survey and submit the results to the Lee County Zoning and Planning Office. F, drain tile repairs. Before any building permit is issued, the petitioner, if the submitted drain tile survey reflects the presence of existing drain tiles in the area of construction, provide confirmation that any drainage tile damage will be repaired to the same or better condition within 30 days of damage. G, weed/grass control plan. That prior to or concurrent with obtaining a building permit, petitioner provide the Lee County Zoning and Planning Office with a finalized written landscape plan inclusive of weed grass control, which outlines when implementation will occur. H, screening. Before any building permit is issued, the petitioner provide the Lee County Zoning and Planning Office with evidence that it has contacted the owner of any adjacent but non-participating dwelling. Again, at this point, they're all non-participating. To outline the ordinance-driven screening options and either reached a memorandum of understanding with those owners for a screen or established a requisite payment. Now, I would note for H, I believe the discussion point for you folks would be because it's a platted subdivision adjacent, there is really no memorandum of understanding. They're all entitled to receive the vegetative screening requirements of Lee County Code. So you could modify that if you desire to reflect that.
So you said because it's a subdivision, everybody in the subdivision,
Everyone in the subdivision, yes.
no matter which side of the subdivision they're on?
They don't have any choice.
They don't have a choice. They have to accept the
But I mean, no matter if they're not adjoining?
correct. It's the same vegetative screening options as required by the code.
That needs to be added, I think. The age.
So you could amend H for the screening, just to note that the petitioner comply with the vegetative screening requirements as compelled by the code, compelled, we'll use that word again, compelled by the code for properties adjacent to a platted subdivision.
Yeah, that would be fine.
I move to approve that with that addition.
We have a second?
Second.
Okay. We have a motion and a second. Any further discussion?
So these are conditions that we're giving to the county board.
That you're recommending that the county board impose, correct?
Right, so they can pick and choose these. They don't have to take all of them at once. Is that correct?
That would be correct in theory. Again, the county board, I'm sure your state's attorney would note, is not allowed to deviate from their own code either. But they certainly can accept or reject your recommendations as desired.
Right, but yeah, in the past, they've been able to pick and choose. They don't take all that we make sometimes, the conditions that we make. And-
Again, that's sort of true still, but they couldn't pick or choose ones that are compelled by your code.
Right. And see, I would like to add another one to this, but I've been told that maybe we shouldn't. And I understand their reasoning, but I think we could, in the past, we could have said, we want the setbacks at a different level than what has been suggested. And now we can't do that.
Because it's a state setback and they don't have to do that. It's only a recommendation to them if they would like to do that.
And that's my point. We could still make that recommendation and they could turn down that recommendation if they so chose.
I don't think we should make a recommendation for them to violate the state law.
Thank you, Rex.
How
It would look
close,
bad on us.
how close is the state law to getting changed?
I'm not too worried about how it looks on us.
I would just encourage you to follow the law.
The current law.
Follow the law.
I'd like you to follow the law, please.
I see. Okay.
At the end of the discussion then?
End of discussion, I guess.
Okay. End of discussion. So we have a motion and a second. We've had discussion. All in favor, say aye. Aye. All opposed? Motion carries.
Now, Mr. Chairman, that would be for the amendment to H. So you still need to vote on the conditions, recommendations under 9A through H as a whole again.
I move we approve A through H. Amended.
I don't think we had a first I made the motion to adopt it as you read the extra screening part.
Well, it's not what I recall hearing, but as long as we have, Callie? As amended or? Right, that's fair. So point well taken. The motion was to approve that section as amended before the motion was made. So
Correct.
we're now on to I referred to as Bess.
We got it covered.
Did we vote on it?
We haven't voted yet
Oh,
I knew I'd missed something there.
because we were deciding that.
whether to.
Oh,
So all in favor, say aye.
Aye.
Aye. All opposed? Motion carries. Move forward.
thank you, Mr. Chairman. This section's I, Bess, battery energy storage system. The petitioner has a condition of any building permit consent to requirements relating to the Bess, namely, 1, modifications to retrofits or replacement of existing battery energy storage system, Bess, design, discharge, duration, or power rating shall be subject to any applicable battery energy storage system ordinance Lee County has in place at the time of the modification, retrofit, and/or replacement of the existing battery energy storage system. 2, a separate building permit shall be required for installation of any BESS. 3, all buildings built for the primary intention of housing battery energy storage system equipment and all other building and/or structures that contain or are otherwise associated with a BESS shall be designed, erected, and installed in accordance with all applicable provisions of local, state, and federal law. 4, any BESS located at the site shall be designed or installed in a self-contained manner, which has a 24/7 remote monitoring and include fire suppression system. 5, areas within 10 feet on each side of the BESS shall be maintained clear of combustible vegetation and other combustible growth. 6, the BESS shall be sited to avoid wetlands, floodplains, or other locations of environmental concern. 7, no BES or related structure shall be located closer than 25 feet to the inside of the facility fence line. 8, all components of the BES shall be set back a minimum of 500 feet from any residence or occupied community building unless a waiver is obtained from the affected landowner. The setback distance shall be measured from the nearest edge of any component to the BES to the nearest point on the outside wall of the residence or occupied community building. 9, all components of the BES shall be set back a minimum of 200 feet from any nearest point on the property line of any non-participating property unless a waiver is obtained from the affected non-participating property owner. 10, all components of the BES shall be set back a minimum of 50 feet from the nearest edge of the public road right-of-way, absent express approved variance by the ZBA. 11, all components of the BES shall be sited so it would be located within the interior of said commercial solar energy facility, within the banks of solar panels lying between the BES and edges of CSEF. 12, the BES engineer's certificate shall be completed by a structural engineer registered in the state of Illinois or by a professional engineer with a certification from a structural engineer registered in the state of Illinois, and shall certify that the specific soil subsurface conditions at the site can support the apparatus given local soil, subsurface, and climate conditions. And 13, the petitioner must provide an emergency response plan specific to the BES after consultation with local emergency responders.
Move to approve 9AI 1 through 13.
Second.
Now, in this context, what I would note for the discussion point is the county does not have a code regarding the setback requirements of a BES.
That was what I was just going to bring up.
Yeah.
So at this point, these are your findings, it's what you're comfortable with, but you would be within your authority to recommend that because they're not currently included in a specific code or state statute.
So there is no state statute on BES.
That is my understanding, correct?
Yeah.
These recommendations.
So these are only our recommendations.
Right, and the recommendation of 500 foot from any resident is excellent. I mean, that's fine. And 200 foot from the property line.
And in
Yeah,
the site plan, it looked like it would be further away from the
Yeah, no, I
house
understand.
than that.
Yeah. And no, these are excellent setbacks. I don't have a problem.
Okay.
My complaint is that we can set these setbacks, but we can't set the other one. That's the issue.
A very valid question, but again, the state statute doesn't dictate those setback requirements,
Yeah.
nor does the county code.
Any
So-
other discussion?
So you said the state law, this January law, has nothing in it that affects this?
I'm not aware of anything in the state statute that would compel a certain setback requirement for a BES compared to a commercial solar energy
All
system.
they said in that bill is that if you've got the solar.
Well, that's a bill, it's not law yet. The one that, if you're talking about the one that was referenced at the public hearing.
Well, the one that passed in January, that one included the BES with the solar field as
But
one
but I'm not
unit.
aware that there was a setback requirement in that.
No, but.
I'm not saying there's not, but I'm not aware of any.
But it's a supporting facility.
Right.
But it's not
Right.
singled out as a setback.
And Ms. Kennedy's shaking her head, so up and, like, yes. You wish to comment on that point?
My understanding of the statute is exactly as you stated, but also that you cannot prescribe setbacks that would prevent supporting facilities from setback can't be sold.
Kick it out of the leasehold area.
There has to be a place on the site where it can be located.
Any other discussion? With that, we have a motion and a second. We've had discussion. All in favor, say aye.
Aye.
Aye. All opposed? Motion carries.
Mr. Chairman, that you, the members of the zoning board, can certainly offer additional findings if you wish to make them. Those are the findings in accordance with the code that you are required to make, or required to address, I should say.
I don't see anything more to do. So,
I would turn it back over to you, Mr. Chairman.
okay. Then we have a motion to recess.
Until when?
Till our next regular meeting for this.
I so move.
We have a motion to recess, and the next regular meeting, scheduled meeting for the zoning board of appeals will be at 7 PM on Thursday, May 2nd. However, we have a few other conditional meetings in between. Anyway, we have a motion. Do we have a second on that motion to
Second.
recess? Second. All in favor, say aye.
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 Oh, there's somebody sick.
We are recessed.